Scene one, ample take two.
That don't come to us with some bullshit lowball number, because honestly, I'm not going to waste time here, and we're going to do what we need to do.
All right.
I started my law firm right out of law school back in 2016. Over the last 10 years, my law firm has grown to be the highest filing law firm of FDCPA, FCCPA, and FCRA cases in the state of Florida. We are certainly the industry leaders when it comes to protecting consumers from debt collection companies, creditors, and credit reporting agencies. Over the years, we have developed a substantial amount of case law, written opinion by judges, siding with the arguments that we make on behalf of our clients. This body of case law that we have established has not only helped our clients, but also many clients in the state of Florida. The government wants to make sure that companies are treating you fairly. With these types of cases, like the FDCPA, the FCCPA, the TCPA, the FCRA, the debt collector has to pay our attorney's fees. Our clients never, ever, ever have to pay us a penny. We don't get paid unless you get paid. Historically, over the years, debt collectors and creditors have been known to be very abusive. They use many forms of intimidation, many forms of abuse, harassment, both verbal and in writing. All they care about is their bottom line. They do not care what the consumer is going through. They don't even care many times whether or not you're contesting the validity of the debt. The FDCPA was passed to protect consumers from debt collectors. Debt collectors, they would be very careful not to violate, but then the creditors would be abusive. The Florida Consumer Collection Practices and the FCCPA is an important piece of legislation passed by the Florida Senate. A creditor has to follow about 200 different rules under the FCCPA. When they violate one of these rules, they have to pay you up to $1,000 for the violation, plus any actual damages, if you have any, and our attorney's fees.